It is such a pleasure to be here, and thank you very much, Jay, for making this possible. Just as a repeat, for those of you who are watching us via live streaming, you will be able to send in your email questions. The instructions for that are on the live streaming website. And in that way, we should be able now and then to respond to questions that are sent in the modern technology format. In addition to that, today's program is going to be captured on video and offered by McGeorge on their website. And it will be done with a little bit of editing to make it work in pieces so that you can watch individual portions of this. We know that this is the start of a conversation and not the end. Well, in addition to thanking Dean Moots, I have a number of people to say right up front that we are appreciative of. First of all, the staff here at McGeorge has been fabulous. Mary Swanson, Sky Foster, who many of you have interacted with as we have done our registrations. Amy Prewitt, who helped us all day yesterday as we were doing details. Alessandra Griffith-Reed, who is our videographer here today. We're calling her Sandy, but Alessandra is her entire name. Jackie Howell, Joy Redmond, Rosa Dennis, all of them have somehow been involved, and I suspect there's probably a few people whose names I don't even know, but who's been involved in this. Melissa Brown is the clinician here at McGeorge School of Law, the faculty member. And originally we were hoping to be able to do this, and then just timing-wise it worked out on the wrong week. But I know the kinds of issues that we're talking about here today, she was already aware of because of the Elder Law and Health Law Clinic that's run here at McGeorge. In fact, that's how I first became aware of issues at continuing care retirement communities. I began running an Elder Law and Consumer Protection Clinic in Pennsylvania at Pennsylvania State University a number of years ago, and a residents group came to our clinic to inquire about legal issues associated with continuing care. And in Pennsylvania, the regulation office is the Department of Insurance. And the resident group at the facility was concerned about a financial issue, and they felt like their facility was not listening to them. The Department of Insurance said they had no jurisdiction over the issue. And so the question was, well, was there a way to facilitate a conversation that might result in that issue being addressed? In part, there was a way, but it was not easy. The residents had to get organized and stay organized, and they were able to present their financial concerns in an articulate way to their community. And they did so at exactly the right moment, because if they had not done that organization, their particular facility was embarked on a plan to double in size, and they would have come online in 2008. For those of us who know about the CCRC industry, 2008 was not the best year. And as a result of their articulate, concerns about finances, they scaled back the project and came online a couple of years later, and that facility has continued to be successful. The facility that was just down the road that came online in 2008 was not successful, and it went into bankruptcy. And so sometimes I learn residents have a very strong and articulate voice about things that somebody should be paying attention to. Well, that brings us to California. How did we get to California? How did a law professor from Pennsylvania end up in California? Well, part of the reason is for a number of years now, I have been approached by residents and lawyers and academics to asking me questions about regulation or laws pertaining to continuing care retirement communities. And so I've always been aware of the California market. It's one of the most vibrant CCRC markets in the country, with many strong and very interesting models, very diverse models in California. By last count, there are more than 100 CCRCs in California. And also California is interesting. Most of the market nationwide, usually we say in the neighborhood of 80 to 85% of the market is not-for-profit, meaning tax exempt in the nation. In California, it's about 75%, 25% by the last calculation, 75% not-for-profit, tax exempt, and 25% being for-profit. And the issues, definitely overlap between the two, but they're always slightly different issues. And so you also have to take that into account when you're doing regulation. The commonality is the thing that I find most appealing to CCRCs, and as I'm always candid in admitting, it's the reason why I want this industry to survive. I want it to be here when I'm ready for it. And I'm hoping that won't be next year. I'm hoping it will be a few years down the road. So I want to make sure this industry is still going to be here. It promotes healthy, active living. In fact, one of the early concepts that emerged from CCRCs was that traditional actuarial tables did not work very well when they first began using actuarial tables because they hadn't taken into effect that people would live longer as a result of the healthy living model. And so they had to revise their actuarial assumptions early on. The commonality is also the contractual promise to provide some form of combination of services for more than 1 year, and in many cases for the rest of the individual's life. There was an academic conference that was somewhat similar to this that was promoted by that little rival academic institution in Pennsylvania, the University of Pennsylvania. I think they're still around. And the Wharton School of Business there, they combined on a conference back in the early 80s that was about CCRCs. And they brought together people who were actuaries, accountants, providers, lawyers, all into the same room to talk about, what were the different ways in which this model could thrive, could improve. And they captured that in a small book, and then eventually several of the people involved in that conference wrote another book in the early 80s. So that was kind of the first of the academic evaluations, early 80s. We're now 2013, and as far as I can tell, there's never been another academic conference. So this is that next wave, I think, of academic evaluation of this model. In getting ready for our first panel, who's sitting right here ready to go, I want to invoke the words of somebody who could not be here today and who is very wise. Mary Anna Colwell is a PhD in sociology, and she's a CCRC resident. She is in Washington, D.C. today doing work, and one of the things I quickly learned about CCRC residents is they're always busy doing something. It's a very engaged community. But she couldn't be here today, and in sending her regrets, she commented that her particular interest in CCRCs as a sociologist, and as a resident, but as a sociologist, was in relationships and community aspects of CCRCs. And she commented that while that was her interest, other people were more interested in the legal and financial side of running CCRCs. But here was the important thing she said. Fundamentally, both concerns demand openness. And now these days we call it transparency. Above all, we're talking about honest communications. And so, invoking the spirit of Mary Anna Colwell, we will begin with honest communications. Our first panel today is residents, and we're going to go, as you all can tell from the agenda for today, we have 4 panels, plus a featured speaker, plus a lunch speaker. We're going to keep you working right till the end today, and all the moments in between. And so our first panel is a panel of residents. And each of them are going to be speaking about giving about a 10-minute presentation of issues they feel are most important. Then we'll open it up for comment and questions, both from our live streaming audience and members of the room, and panelists talking among themselves. So we're going to begin with Buzz Gitelson. We also have Margaret Griffin, and we have Barbara Krigs speaking today. And I'll let them decide how much they want to say about their backgrounds, but all of them are accomplished in their own rights. Buzz, please start us off.
Morning, everybody. My remarks here are with my hat on as a CCRC resident. Over the years, the last 7.5 years, my wife Peg and I have lived in two different CCRCs, one not-for-profit and one for-profit. Court has, just as Catherine has suggested, there are some similarities and there are some differences, but the issues that we're talking about today really pertain to both. However, I practiced law for, I guess I've been practicing law for 47 years. And having burned out fairly early, the last 15 years of that practice have been without getting paid most of the time. But necessarily, it's hard for me to get away from my lawyer's skin. I want to say that I am a finance and business lawyer, securities lawyer. I'm not a litigator. And I believe that the issues that we're talking about, the evolution, if it's happening, the change, is change that ought to happen in discussions between residents and providers rather than in the court for a lot of different reasons. But then again, the notion of change is in the eye of the beholder, and this idea of predicting, making predictions is, as we said, very difficult, particularly about the future. So I would be foolish on the one hand to tell you that, suggest to you that change is happening, and perhaps even more foolish to suggest that I knew how it was going to come out. Nevertheless, rushing right in, I'd like to identify two of at least three essential elements of what I believe are elements of change that are going on right now in this CCRC industry. The first deals with governance and management. And the notion is, wouldn't you expect change? After all, the CCRC industry has now existed, I should say the model has existed for over a century. Wouldn't you expect it to change over that time? In that respect, it seems clear that the early model of CCRCs was that even though a CCRC resident was coming into independent living, that nevertheless the assumption was that the CCR resident would not want to, or indeed perhaps have the capacity to actively exercise the authority to participate meaningfully in the governance of his or her community. And what are the, if I'm right about that, what are the implications of this conception? They are that residents would essentially be passive, and the providers would be, in essence, custodial. Now, you'll excuse me, I'm going to be guilty of some hyperbole here because there are obviously various blends and shades of all this, but for my purposes, let me use the extremes, if you will. I call this the go play and we'll take care of you attitude. CCRC legislation reflected these assumptions, and CCRC laws often assumed that the residents were going to be essentially passive. Indeed, Section 1771.7 of the California CCRC law suggests that the provider is to encourage the residents to form an association to provide a vehicle for them to indicate their concerns. It's a somewhat paternalistic attitude that implicitly that they needed to be encouraged to do that, and the provider ought to help them to do that. And but in any event, this residents association is very clearly to be always advisory and with no right to participate in management or governance. However, the resulting residents councils that were formed, at least in my experience, from having looked at a couple and observed some others, is that the councils themselves tend to want to keep the lid on, if you will. They tend to want to protect their fellow residents from the issues that arise that the council decides or needs to discuss with the provider to protect the residents from them, because after all, that might cause some people to take it out of context, become unduly concerned. And so there is some custodial attitude even among the residents themselves in the process. And keep calm and don't be troubled by these. I call this the keep the lid on attitude. That's the original conception. The changes in resident profiles lead to changes in resident expectations. We all recognize this phenomenon that people are not only living longer, but they're living more vitally. as Catherine has suggested. They're more actively engaged, both intellectually and from the standpoint of their physical ability to be involved and engaged. That vigor and decisional analytical skills are evidenced, particularly, if you will, by the, just as an example, by the RVM PRS discussions. It was clear, if you are aware of those discussions, and I'm sure that there'll be some discussion about it later today at length, that the residents there needed, certainly they were appropriately assisted by counsel, but in terms of the ability to analyze and to negotiate, they didn't need any help from outside. They had the power to do that. So looking at what's happening to the aging process in general, to seniors, wouldn't you expect change? And this change would reflect the fact that moving from one's home, one's condominium, into a CCRC, independent living environment, does not suggest that all of a sudden you can't do what it was you were doing before you moved, participating in your condominium board, governance, participating, of course, taking care of your own home. So one would expect that people coming from that environment, attaining the intellectual vigor, would be interested in taking part in the governance of their own association. Now, I don't want you to take this wrong, in the sense that the Pareto principle, which is also known as the law of the vital few, will continue to apply. That doesn't mean that every resident of every CCRC is going to want to be involved in the management of the CCRC. It means that probably a small percentage of them, maybe 20% or less perhaps, will want to be involved. But their involvement, their willingness to participate as instruments of this change that I believe is happening is what is helping for the changes to come about. So what are some of the changes that one might expect if you expect change? And one is the change we're seeing, and we see reflected in the RVM PRS settlement agreement, the movement toward residents becoming fully voting members of their of the boards of their providers, and also being qualified to be members of the executive committee. Second, and probably of greater significance, is a change in perception. And that is the perception that residents are not supplicants in their own view. We're not talking about from the provider standpoint, but from the resident standpoint, the willingness to recognize that residents are contracting parties, and as contracting parties, they have the right to interpret their contracts, just as the provider who has prepared the contracts interprets them. And given that the contract is, these contracts, as we know, are so-called contracts of adhesion. That is, there's nothing wrong with a contract of adhesion, by the way. People tend to take that as majority in some respect. If you ever looked at your parking ticket, it's a contract that you don't negotiate, you just take it or you don't park there. And that's very much the way entrance agreements are, residency agreements are for CCRCs. There's nothing wrong with that, except that if there is ambiguity, if there is some construction that's capable of more than one interpretation, then the provider, having drafted the contract, bears the burden of that, and the resident has the right to expect it will be interpreted in a way that a reasonable resident would interpret it. Besides that, the notion of residents as contracting parties is the willingness that residents will start to have to challenge performance and the risk consequences. There has been the concern, as you can imagine, that, well, if we make waves, that is, if we say that there's something that we don't like, or there's some respect in which we believe the provider should act differently, that there might be retaliation, there might be reasons, and after all, we're essentially asking for favors. And that attitude, which still continues to exist among many residents, I believe is gradually changing to a willingness not only to interpret a contract, but to ask the provider when the resident doesn't believe that the provider is performing in accordance with the contract. And finally, in this respect, the pot of gold that CCRCs provide, that providers provide, is peace of mind. That's basically what you're here. Come here and, as Catherine said, age well and enjoy a vibrant, intellectual, and active community. And if that's the pot of gold, then the argument is, should the provider be held to the gold standard? And the gold standard in contract terms, putting my lawyer's hat on, is the notion of fiduciary obligations. And that's a notion that suggests that one is not just contracting at arm's length, but that one, as the fiduciary, owes an affirmative duty of candor to the person who has the benefit of the fiduciary obligations of the provider, and to act in the very best interests of the residents in that case. And perhaps, although it is the shortest provision in the entire of the settlement agreement, and each of you who has a binder has a copy of the settlement agreement between RVM and PRS. And if you get a chance to look at section 1.9 on page 5, it's very short, so I'll read it. It just says, every RVM director must, prior to assuming office, agree that as a director he or she has a fiduciary duty to RVM. PRS agrees that it has a fiduciary duty to RVM. Those are very few words with great meaning for the future operations of RVM as an entity. I think I'm going to stop at that point, and we'll take up the rest of what I wanted to talk to you about hopefully during the question period. And you, by the way, you have copies of my slides in the materials. Thank you very much.
Our next speakers are Barbara and Margaret. And do you want to come up here, or do you want to speak from there? Okay, great.
Good morning. I am here under false pretenses. I am no longer a resident of a CCRC. I moved out 3 months ago after 18 years in the same community. Why did I move out? I moved out for one reason and several others, but I'm not going to talk about all of them. I'm just going to say that in 18 years, my monthly care fee doubled for the same services. Everything is the same, but my monthly care fee doubled. I could no longer afford to live there, so I moved out. I now am the proud owner of my own home, and I'm having a lot of fun. I miss the socialization. That is a very important thing. Being a resident for 18 years in a community gives you quite a perspective on what's going on. I became an advocate for resident interests. I'm not going to say resident rights. Resident interests, almost immediately upon moving into my community. I was fortunate enough to come into contact with Maud and Jim Transu, who were the founders of the resident association in California known as CalCRA, California Continuing Care Residents Association.
We're going to ask you to just not lean into the mic.
Okay,
It's a very strong mic.
is that better?
Yes.
Jim and Maud gave me a perspective of providers that was pretty hostile. And they were the true grassroots organizers. They, on their own, traveled from community to community throughout the state, on their own, talking to whoever they could to try to galvanize interest. Something as Buzz was talking about, to try to galvanize interest in something which was of a common theme, has to do again with money. Constantly rising monthly care fees was the problem. And people were upset about this. So that was the common theme that brought people together. And finally, the emerging incorporated California Continuing Care Residents Association. After Jim decided he was going to retire, I was then elected president. I served 2 terms. And during that time, I had, the interest that I had was in getting a resident representative with a vote on the provider board of directors. That was what we were trying to do. And we, at that time, did not have a lobbyist. And so it was direct negotiation between providers and residents. There were 3 residents, volunteers, facing a table full of providers to negotiate the terms of this. Halfway through the negotiation, which lasted over a year, we finally found someone who would work for almost pro bono and become our lobbyist. His name was Mark Brown. When he took over, things changed tremendously because he had the resources that we lacked. We've passed the bill, and it had a lot of wonderful things in it for the benefit of residents. But we were not able to get the vote. We did get a resident representative on the provider board of directors. And because contracts vary so much throughout the state, negotiating anything like this is very, very difficult, but we did do it. Now, that issue, as important as it was, now we have another issue that I have taken on, and that is, as you know, the governing body, oversight, that has oversight, is the California,
Social services.
What?
Social services.
I'm having a senior moment, I'm sorry.
Social services.
California Department of Social Services, but we have the, no, that's not the name of it.
Continuing care
Office
contracts.
of Continuing Care.
Well, I'm sorry. You have to realize I'm going to be 90 years old next month.
You got the man over here, you just asked him for it.
Bob Thompson, yes, I know. But that body, who has financial and licensing oversight over the industry, is almost non-functioning at this point. And it's my thing to try to change that, the legislation that put this body into place. Something has to be done about this because there is no effective financial oversight. The licensing is still in place, but the financial oversight over the industry is lacking, totally lacking. This must be changed. Now, during the 18 years that I served on various things, I served on the advisory committee to the Continuing Care Contracts Branch, which is the name that escaped me, Continuing Care Contracts Branch. It was not effective then, and it's totally non-effective now. We need to do something about this. Always these financial matters are the ones that are predominant, which is unfortunate, because the time that I spent at my community, I thoroughly enjoyed living there. The services that I had were very, very good. I enjoyed every bit of it. That was not the problem. The contractual services are always met, and sometimes even more so. But now, there were other issues with the community where I lived, where I tried to galvanize interest and failed totally. I really had a bad experience in that respect, because the resident council which should have represented my issue, which I'm not going to get into, refused to do anything about it. So that was another reason why I left the community, because I felt that there was something going on here that needed to be changed, but I was the only one that wanted to do anything about it. So this is very much in keeping with what Buzz was talking about. It's very much alive and an issue. The time that I spent in my community was rewarding, and it was the socialization that I had there. I miss that in living by myself now, although I'm still very close to a lot of my friends. But my whole experience as a resident was a mixed blessing. I can't exactly say that it was a bad experience or it was just an experience that was evolving and constantly evolving. And one thing I would like to say that what we're doing here, all of us here trying to do, is a step and a half in the right direction. This is so much needs to be discussed. So many things need to be changed. Although we have already had a lot of changes, they haven't touched what is the real problem here. And that is the way that the residents are, as Buzz mentioned, paternalized by the providers. This is not a good thing. There is the respect that they should be giving us, because after all, without us, there wouldn't be much of a CCRC industry. Thank you so much.
Good morning. My name's Margaret Griffin. I'm an 8-year CCRC resident, and I'm also the current president of CalCRA, the statewide resident association. Only 38 states have specific CCRC regulations, and in those 38 states, CCRCs are overseen by a variety of bureaucratic entities. Could be the departments of finance and insurance, most usually. In this state, as Barbara said, it's the Department of Social Services. So there's really no consistency between states in terms of oversight, type, or effectiveness of regulation. But in California, we often hear that we're the most regulated state when it comes to CCRCs, which sounds pretty good. But given the variety of approaches statewide or nationwide, merely having a lot of laws on the books really doesn't say very much. We're really actually at the top of a pretty meager heap when it comes to regulations, I think. And the statutes that we do have largely reflect the interests of the providers at the expense of meaningful consumer protection provisions. So this morning I'd like to talk a little bit about and share a list of specific issues that CalCRA feels are important and will be supporting to try and change our current law to strengthen resident rights and improve the transparency and accountability in the operations of our communities. First, as Barbara hinted, we'd like to see transfer of the financial and contractual oversight of our communities from the Department of Social Services to the Department of Insurance. We feel it's necessary because the actuarial and financial expertise required to really oversee our communities resides within Department of Insurance, not within Social Services. Second, we'd like to foresee the requirement that all CCRCs conduct periodic actuarial studies to assess the financial condition and long-term viability of their organizations. Currently, this is required only for facilities offering Class A or life care type contracts, but we feel that it should be applied to all CCRCs. We would like to see that financial information that's currently required to be provided to residents only every 6 months instead be provided quarterly and include a written explanation of any significant budget variations. Now, this may sound like a big deal, but we don't think it is. We believe that providers distribute this kind of information to their boards right now, and we just think that it should also be extended to include residents so that residents are equally informed. We would like to see the establishment of a firewall between the CCRC and its parent or management company, specifically to protect the assets of the CCRC so that they cannot be pledged on behalf of other activities of the parent company. And as has been said several times this morning, we would like to see an acknowledgement of the provider's fiduciary responsibility to residents. Providers, particularly the nonprofits, like to say that they are mission driven, that they're in this business really to do good and provide services to seniors, which sounds very heartwarming. But I gotta tell you, depending on who says it in the context, I tend to find that either insulting or irritating. I'd prefer to see the fiduciary approach that acknowledges the imbalance of power in the provider and resident relationship and makes it clear that the provider has an obligation not to screw over me. I think that's an accepted legal concept. But it basically means that they are to act to protect my property. They have an obligation to act for my benefit, which is different from the condescending pat on the head that Barbara referred to. We would like to see that all nonprofit CCRC board meetings, except for executive sessions, are open to residents. And we would like to see that all boards have an audit committee and a nominating committee consisting of independent directors or trustees. You know, some of these elements you'll recognize from Sarbanes-Oxley legislation that came about as a result of the Enron debacle in terms of how private industry operates, and we think a lot of those concepts have resonance for our industry. As the next, to provide or require a self-evaluation of all nonprofit boards be conducted, and that the evaluation be made available to residents. We would like to see provider investment policies clearly articulated in writing and made available to residents. And as you've heard several times this morning, we would like to see a minimum of one resident as a full voting member on CCRC boards. I think it's important to recognize that this is already law in Washington, D.C., Maryland, and New Jersey. It's established practice with the Kendall Corporation, which operates probably a dozen CCRCs on the East and in the Midwest. And interestingly enough, there are at least 5 California communities that have voluntarily adopted this practice, so it's certainly not unreasonable. IRS ruling 72-124, which establishes a tax-free status, requires that CCRCs be operated at the lowest feasible cost. So we would like to require that our boards annually determine that this requirement has been met, and then share the basis for that determination with residents. We would like to see posting on the CCRC's website of all the information reports that they are required to file with Department of Social Services, including their IRS Form 990. We would also like to have our providers report to residents quarterly on any complaints or concerns that have been filed with them, with their management, board, or Department of Social Services. We'd like to know how those complaints were resolved and when any unresolved issues will be resolved. Those are the issues that we have before us, and I'd like to hear what you think, or if there are other concerns or issues that members of the audience have. Thanks.
Well, I thought we might get the fireworks started before too long, and I think we've begun. We're at the portion now, we have about a half an hour when we can entertain questions from the audience, discussion among the panel, and anybody who is watching us via the live streaming, they can certainly send in comments or questions by email. Why don't we start with the audience? Is there anybody in the audience who would like to speak? And unfortunately, what we're going to have to do, if you say the question, I'll repeat it so that we have it captured for the recording. Anybody in the audience like to start us off? Yes.
I was wondering if we could get a little more specific about the periodic disclosure requirements that the calendar was proposing. And in particular, disclosure requirements to prospective applicants, residents, and periodic disclosure items.
All right, the question for the camera is, could the commenters, the panelists, talk a little bit more about their interest in disclosures, periodic disclosures, what might be included in those disclosures, and whether you would also include not only current residents, but prospective residents, people outside the community who might be considering that community.
Me too.
Yeah, you can speak right from there.
Is this
And it's on, it's very on.
Just again, using a securities lawyer's background perspective, the SEC has evolved a notion of management's comments and discussion of financial condition and results of operation. They call it MD&A. And so when one buys a security from an issuer in the public markets, and as well if one is a security holder, receives a report from the issuer, an annual report that's filed with the SEC, it contains this so-called MD&A section, which is a little bit more than the board's self-evaluation that Margaret was referring to. Let me just give you a quick statement of what the way it's described in the SEC's release that first proposed this MD&A disclosure back in 2002. It says, and I'm going to just change the language a little bit to refer to regulators as distinguished from issuers. And it says, management's discussion and analysis of financial condition and results of operations. What about adopting the thrust of this kind of disclosure? In quotes, information that the provider believes to be necessary to an understanding of its financial condition, changes in financial condition, and results of operations with particular emphasis on the provider's prospects for the future. That would be provided to every prospective resident as well as to every existing resident annually. It's the provider's own analysis of the recent results of its operations and what it sees as the challenges as its financial resources going forward. Just along the lines of disclosure, further disclosure to existing residents, the so-called key indicators report is a portion of the annual filing the providers make now in California, and it's a fascinating document with a lot of information in it. It's not easily accessible. It's available. It's a public document. It's available from the branch. If the branch were able to automate it and to supplement it, for example, with the branch's own analysis of what general trends are. Walt Rosette, who's here with us today and who was formerly president of Caltra, has observed that the key indicators report would be much more meaningful if they included a standard set prepared by the branch against which the indicators could be compared, and an average of California's CCRCs for each indicator. Comparing that average year after year would provide an indicator of where the industry is heading. These are examples of the kind of additional disclosure we might provide.
Barbara, do you have additional observations?
Not specifically. I think what we're really interested in is getting the information to residents timely and in a format that's understandable. As Buzz indicated, there are reports that have to be filed annually now from the providers with social services. And even though that information is public, it's not readily accessible and therefore really not very usable either by current residents or prospective residents in terms of getting a look at the industry as a whole or getting a look at a particular facility.
Can I make just one more comment, and that is in a parent subsidiary structure, this is a particularly challenging, difficult issue, because to the extent that the financial disclosure exists, it exists with respect to the subsidiary being the provider, and not with respect to the parent. And often, the subsidiary is very much controlled by the parent in many respects. And the financial relationship between the subsidiary and the parent is such that without information about the financial condition of the parent, one is only getting a small part of the picture in real terms. So that's one of the challenges I think we face going forward in parent subsidiary structures, is the risk to the resident is that the resident, the prospective resident, doesn't know anything about what's going on up top. They just know about the provider.
Opening back up to the audience. Are there other comments or questions? Yes.
What would the resident, say a resident who's sort of locked in by an entrance fee, a non-refundable entrance fee, what would they do with that, with the disclosure information? How would it change the residential experience?
So the question is, how would it change the residents' experience to know more about the finances if they are in a single entrance fee model, is that what you're saying, or any entrance fee model?
Well, I gave an example of a resident who's, as one person said, well, you residents have glue in your seats because your entrance fee is gone.
Okay, so once you paid your entrance fee, how would it help residents to know this additional information?
If one posits that residents ought to have a more meaningful participation in their governance, as Margaret has pointed out, financial, and Barbara as well, financial aspects of the operations, the continued ability to provide the promised services going forward, and the trends in the financial condition of the provider. If one is to be able to analyze that, and there are residents who can do that. There are residents with financial backgrounds, business and financial backgrounds. Many residents have it, and the interest in doing it. In order to do it, you need to have the financial information to work with. And so even though your entrance fee isn't refundable, having that information allows you to participate more meaningfully with the provider in looking at what's happening to the institution. And for example, and I think the example Catherine provided at the outset of a resident group who was able to analyze a proposal to materially increase the size of the provider at a time when the residents didn't feel it was justified. With the information and the expertise to do so, they were able to make a contribution which ultimately, in 2020 hindsight, allowed the operation, the CCRC, to continue.
Well, and I think a more recent example even is what happened at Rogue Valley Manor, where the residents were able to take the information about the operation of their particular CCRC and the parent corporation and file a suit that was ultimately settled with some important benefits to residents.
I suppose it's possible that the providers might argue that's exactly why you shouldn't have the information.
I could certainly see that
I would
being
like
a
to think
response.
in the long run, though, that residents that are engaged and involved in their facilities make it better, make it stronger. You can tell when you walk on the campus what the environment is. And ultimately, that's what's attractive to potential residents.
Let me ask a question in my role as devil's advocate. In 2008, there clearly was an economic recession that not only hit the global markets hard, hit CCR industries particularly hard because of the importance of prospective residents being able to sell their homes at high dollars. And when the housing market fell apart, so did that ready available supply of people who could sell their homes and move into a CCRC and pay a high entrance fee. Are the concerns that are being raised by CalCRA, too focused on the impact of the 2008 recession, or do they go beyond that particular financial event?
Well, I think certainly that financial event is very important, but I do think it goes beyond it as well, because if we're going to look at a long-term strong industry, we have to look at how it's going to operate. And I think having the financials in place, making that information widely available so that we can get the best possible approach and setup is what we need.
Just to take the provider's point of view, I think it's important for all of us as residents to recognize that providing information and taking on increased responsibilities, if that is to happen, involve costs, and cost to the provider, and therefore inevitably cost to the residents. You can't have it both ways. And there will be additional costs, and there also will be perhaps fewer prospective providers who are willing to come into an industry that's more heavily regulated. It would be good if we could avoid materially greater, heavier regulation. But the only way we're going to do that is for the providers end of the industry to recognize what's happening and decide to get in front of it and do what will ameliorate some of these concerns. And that's the negotiating process I was referring to earlier.
And I think, truly residents and providers at the end of the day want the same thing. We all want our communities to be successful.
One of the proposals that you've raised, and has been raised in other communities or other states as well, is this idea of residents serving as voting members of boards of governance of their providers. What about the potential for a malcontent, somebody who simply cannot find anything that they're happy with being elected? What's the way in which that won't be a problem for the boards?
Well, I would assume that would be handled the same way any board now would handle either a malcontent or someone who turns out to perhaps not have the strengths that the board initially anticipated that they would have. I don't think that it would be crippling necessarily in any way, and the board would probably deal with that in terms of the person's service on the board, and if it's not valued. I think residents would bring a different perspective.
Yeah, I think the perspective is important, but the possibility of someone who is not constructed being appointed to the board always exists. Hopefully the residents, having been given this opportunity, would exercise it with as good judgment as they could bring to electing a representative who will represent their views, but do so in a constructive manner. And it's obviously the case that someone who is going to do so principally by ranting and raving about everything is not going to contribute to the effective functioning of the board. And now we're talking about still, of course, residents representing a minority on the board. as Margaret has said, if you do have someone on the board who's a minority and not constructive and making it difficult to operate, boards manage to get the work they need to do done in spite of that in various ways.
The other interesting thing that I found in researching this issue over the last year, I talked to someone from Kendall Corporation where they have done this as a matter of corporate practice for years. And I've spoken to resident board members in Maryland and Washington, D.C., as well as here in California at those communities where this is happening. They're all consistent about the value of the resident perspective and that it's important that the resident board member, just like any other board member, you have the interest of the entity first. You have to be able to set aside personal interests, small interests, to look at what's best for the facility. And a resident can do that as well as anybody else. And that's really the key to having an effective resident as a board representative, I think.
Let's open this back up to the audience. And the back row, and then we'll come to the front row. Back row first, then front row.
Okay, thanks. My name's Mike French. I'm from New here, and I'm kind of new to this. So I just had a question. I heard that some of the specific fears of residents are continually increasing monthly fees. I'm wondering if you could talk to some of the other specific concerns that residents have, and how a move of oversight from DSS to perhaps the Department of Insurance would change that or help that.
Okay, so the question for the camera is, what fears of residents exist in addition to or besides the concern about rising monthly service fees? And how specifically might movement of oversight from the Department of Social Services to a Department of Insurance type of arrangement change that dynamic? From your perspectives, obviously.
As Barbara suggested and Catherine, and Margaret has noted, right now the continuing care contract branch does not have the tools to address the kind of financial regulation that is appropriate to protecting the interests of residents in these CCRCs. It's not that they don't exercise it, it is that the statute doesn't provide it. It provides what is only a sort of thermonuclear war power when the condition of a provider has deteriorated to such point that it's on the verge of being unable to fulfill its mission, that any action can be taken by the branch. So the legislation needs to be modified to permit that. That's a major concern in financial oversight. But it's not financial oversight intended to be in a punitive sense. It's intended to be able to intervene and participate if it sees a provider moving in a direction or it sees trends in its finances and operation that are worrisome from the standpoint of its continued ability to provide its services. So that needs to be changed. I differ a little bit with Margaret in the sense that I don't think that it's absolutely necessary to transfer it to the Department of Insurance, that function. If in fact the legislation, two things have to happen. One, the legislation has to be there to provide reasonable and effective financial participation, oversight, if you will, of the branch. And two, it needs to be given the personnel to carry that out. I mean, Bob Thompson is a JD MBA, and he has 17 years of experience here, and he can do that, but he can't do it alone, and he can't do it without the statutory authority to do so.
Good, thank you. In the front row.
Yes, is this model of the parent subsidiary the only model that exists within the industry? Is there no such thing as a self-contained, self-governing, single corporate entity?
Okay, so the question is the parent subsidiary model the only model that is practiced in this industry, or are there also self-contained units that are entirely unitary in their operation? I know from Pennsylvania's perspective there are multiple models, and nationwide there's just an extraordinary array of models. But I'm sure in California, what about in California? Are you aware of any non-parent subsidiary organizations?
There are some, not that many, but there are some.
And one of the impacts of that has happened in the industry, certainly as a result of the 2008 financial crisis, is there has been a recognition of strength in numbers. And so there has been somewhat of a tendency of the industry to draw together and share finances and share, and thereby lower the cost for the individual units through that. So that has been a tendency since 2008 somewhat. I'm assuming that's perhaps also happened in California. Other comments or questions? Do we have any coming in from our streaming audience?
Not yet.
Not yet? Okay, good. How many people here are are somehow associated with a continuing care community right now?
Wow.
Okay, so many people. How many people have never been to a CCRC but are interested in the model? Okay, so really one person who's in the never been there yet, but interested, and pretty much of the room has some connection to CCRCs. How many are on the provider side of CCRCs in the room? Okay, so we have a smaller number of provider side, but thank goodness we have you. And most importantly, we're hoping that you will speak as well, because part of this is we want this to be a conversation from all sides of the perspectives. I mean, one of the questions that often comes about, we were talking about this before the program started today, I was talking to one of the attorneys, and there is a tendency in this world for the problems to dominate the good, And so if there is one particular problem child in the industry, everybody focuses on that problem child, and we assume that everybody has the same problem. To what extent is this a small percentage of the communities in California that raise concerns, to the extent that you're aware of this, to what extent do you think this is really that many of your concerns are widely shared among residents? Do you have a perception of that? Have you done, for example, a resident survey in California?
We have not done a resident survey, and I really don't.
I realize it's harder to do in California than a small physical state. But it sounds like that might be useful to...
No, I think it would be very useful. I think it's interesting that, for instance, we're part of an organization that has 10 CCRC operations. And although the chairs of the resident councils of each of these organizations has each other's, each one has a telephone list for all the others. They talk to each other very little, and they protect that list very carefully. And so it's not easy. It's not really facilitated for the residents of the various CCRCs to talk to each other about common problems. So it's hard to know. I suspect personally, I know that there are other discussions both going on and that have gone on, other negotiations, if you will, between residents and providers, both in California and outside of California. On occasion, they ended up in litigation. Most of the time, those that have taken place have been settled as they should have been settled in the negotiation and mediation process. But exchange of information, other than organizations like CalCRA, but exchange of information among resident councils, I think is almost, at least to my knowledge, almost non-existent in California.
I think it's generally not supported by providers. They would really prefer to keep things insular and to keep control of it. I had an interesting experience a few years ago when I first got on the CalCRA board, and I thought, gee, this is great. We ought to be able to expand membership and contact some of these other places where we don't currently have members. So I got the list of communities from social services and started calling around. First you hit the reception desk, and I asked for the chair of the resident association or resident council. And they wanted to know who I was. They wanted to know why I wanted that information. And I invariably got shunted off to marketing or an executive who told me, quite frankly, that that information was confidential and they really didn't want me around.
Well, there is, just in defense of that, by the way, there is a real issue of confidentiality. And from the provider standpoint, the provider probably ought not to get involved in providing a lot of resident information, but the residents ought to do that. To the extent that we want to have that kind of interchange, we've certainly got the power. There's no restriction on it. We've got the power to do it. We just hasn't gotten done so far.
Now, we've mentioned this organization, CalCRO, but perhaps we should define it more clearly for people who might not be aware of it. CalCRO, what does the acronym stand for?
California Continuing Care Residents Association. It's strictly residents of CCRCs. And we live on dues from residents. We don't have any other grants. Because we are a 501c4 organization, we don't get any kind of help that other nonprofits typically get in terms of grant support or foundation support.
Do residents of a community belong through their community? How do they become involved in CalCRO?
In this state, they're all individual members. In some states, like I think New Jersey, the community is the member entity, but here it's all individual members. We have about 2,100 members currently out of approximately 20,000 CCRC residents.
Yes, we have another question.
I would observe that from a provider's standpoint, perhaps the single most important factor in maintaining a viable community is occupancy rate. From a resident's perspective, do you have any input on occupancy rates in various communities?
Well,
So let me just repeat the question for the camera. So the question was about the importance of occupancy rates for the provider. How do residents feel about that same occupancy rate information?
Residents are very interested in occupancy, and in most communities, I'll give you mine for an example. There are residents who have volunteered, who want to host prospective residents, who make their apartments available to show prospective residents. Residents are very interested in occupancy, and they realize that if we're going to have a viable community, we need to keep it full.
I'm taking that really down to where the money is. There is nobody else who's contributing. The budgets of CCRCs are all funded by the residents. That's where the money comes from. And consequently, once you fall below certain levels of occupancy, you start to have some serious financial problems because there's nobody else here to pay the bills. And consequently, at least in concept, if the occupancy level falls to some levels, lower levels than one would be desired, and it's not very low, by the way. We're not talking about falling to 60% or 70%. We're talking about falling into the low 90% occupancy. You start to have the kind of financial problems where we've got to do one of two things. One, we've got to cut services or the quality of services, or two, we've got to increase monthly fees, neither of which is a happy thing to have happen in your community, and consequently, residents have a real financial interest in the continued high occupancy of their CCRCs. And as you can imagine, that creates something of a conflict of interest in the sense that if the residents and the providers are sparring about something, at least publicly, if they're sparring about something, or if there's some concern about there's a lack of they don't get along, that's what I'm trying to say, that's certainly going to affect a decision of an intelligent prospective resident about whether to go there or not. And that's one of the issues that drives residents and should drive them in trying to reach agreements about things that they're concerned about in a way that preserves or avoids mutually assured destruction, if you will. That it might hurt the provider, but it will certainly hurt the community as well.
We had a comment from the live streaming that pointed out to us that nobody had yet talked about the importance of the contract in the relationship between the residents and the community, and that the contract really, in many respects, is everything, and both good and bad. And I think we'll have opportunities to talk about that role of that contract as we go forward in in the sessions, particularly in some of our afternoon sessions. Yes?
I had just 3 comments on what I've heard so far. I'm a resident of about 6 years, and I think some of us move in with an unrealistic expectation. I certainly don't like paying when it goes up every year, but I also, and more importantly, don't want the quality of the service to go down, whether it's food, house cleaning, maintenance of grounds. So I'm more concerned about that, frankly. I do think that people should probably read the contracts a little better before they decide to make a commitment. And I would say particularly with C contracts, because they think they might not need the medical care, but, and they think that they might have long-term care, but when they really need it and get into those contracts there with their insurance companies, they find out that it doesn't come close to meeting market costs these days. And we too belong to CalGov from the place we been in. And we went to several of the meetings in-house. So I'm only speaking for our facility. They were so negative and so gripey that we never wanted to go back, even though we do pay our dues every year, because I do think every industry needs a watchdog industry. But it just can't be so negative.
Okay, for the camera, important comments. First of all, from a resident who's been a resident in a CCRC 6 years, she said she may have gone into her occupancy with unrealistic expectations, and others might as well. That on the one hand, she, like anybody, does not want to see costs go up on a monthly basis, but more importantly, she doesn't want to see services go down, and there's that clear trade-off. She also commented about the importance of Type C contracts, which are sometimes, that acronym is used for fee-for-service contracts. We'll talk a little bit more about the different ways in which these letters can be confusing. And she was commenting on the importance of really understanding a Type C contract so that you don't get into that format, not realizing how much you will have to fund on your own and may be unable to fund on your own. And then finally, an important comment about CalPRA, that a meeting, the perception was that it was a gripe session and that it was negative and that was not useful. Response?
Well, I think that's a really important consideration, and a lot of times I think what happens at local facilities is really driven by local personalities. And as I said earlier, residents really have the same basic interests that the providers do, and that is that the facility be successful, which means you need to find a way to work together. Now, what our administrators may call successful might be, no staff problems, no complaints from residents. What residents call successful might be good food, a well cared for facility. That doesn't mean one is right and one is wrong. It's all important, and it has to come together to be an effective community. And I would just hope that perhaps the personalities may change at your facility, and that there's opportunity for a different kind of dialogue.
Well, with that comment and important response, let's take our break. Let's come back as close as possible to 11:25 as we can. And we'll get started with our second panel, and I know we'll have some important things to talk about with that second panel. There are restrooms on this right side of the